Good evening, ladies and gentlemen, and welcome to Edinburgh University and the Edinburgh Law School. It's my great pleasure as Dean of the Law School to welcome you all this evening and to this very happy event. I'm not quite sure if the condemned man in the front row thinks it was a happy event, but we certainly do. So it's my great pleasure to welcome you all. Just to say a brief word about the format of the evening. Paul is going to deliver his inaugural lecture, and then, as is customary and as is a great privilege for those delivering an inaugural lecture, there are no questions allowed. So if you try to buttonhole him over a drink afterwards, he may deign to give you some answers to some questions, but otherwise there will be none given this evening. So we move straight from the inaugural lecture into a well-deserved drinks reception afterwards, just at the back. So that's the format of the evening. So it's my great pleasure to say a few introductory words this evening before the inaugural address of our esteemed colleague, Professor Paul du Plessis. Paul began his legal studies in his native land of South Africa. He was awarded 4 degrees by Potchefstroom University, a B. Juris Cum Laude in 1995, a B.A. Hons in 1997, an LLB Cum Laude in 1998, and an M.A. Cum Laude in 1999, in which he specialized in medieval legal Latin, writing his dissertation on the Tractatus of Bartolus. Doctoral study followed under Professor Laurens Winkel of Rotterdam on the subject of the history of the remissio Mercedis and related legal institutions, Paul receiving his PhD in 2003. By that date, we had been lucky enough to lure him to Edinburgh. He joined the law school staff as a lecturer in 2002 and was promoted to senior lecturer in 2009 before having a personal chair in Roman law conferred upon him in 2017. Paul is an internationally renowned legal historian, having held visiting professorships at Milan, Santiago, Bangkok, Rome, Trento, and Szeged, as well as visiting fellowships at Cincinnati and Cambridge. His research focuses on the multifaceted and complex set of relationships between law and society in an historical context. His main field of research is Roman law, with specific reference to property, obligations, and to a lesser extent, persons and family. Within this field, his research is concerned with the context within which law operates and the extent to which modern socio-legal methodologies can be applied to historical material from the Roman period in order to further our understanding of Roman law. To that end, his work contributes to the formulation of a methodology for law and society research. In the context of his interest in law and society, Paul's research also focuses on a further period where Roman legal principles were used to create law, namely the period of the European jus commune in the later Middle Ages. Here, his research explores themes such as structure, doctrine, and legitimacy with a view to challenging the accepted macro-narratives of European legal history. In recognition of his contributions to legal history, he was elected a Fellow of the Royal Historical Society in 2012. Paul's a member of various organizations dedicated to the study of legal history, the Selden Society, the Stair Society, and the Southern African Society of Legal Historians, and he contributes actively to the web pages of the Centre for Legal History at Edinburgh, primarily as co-author of the Edinburgh Legal History blog. Since 2016, he's been the director of the Centre for Legal History. Paul also convenes the Edinburgh Roman Law Group, one of the most prominent groups of discussion of Roman law in the UK and Western Europe, and he's also co-director of the research network Ancient Law in Context, hosted jointly by the School of Law and the School of History, Classics and Archaeology here at the University of Edinburgh. Somehow finding time for yet further academic contributions, Paul is also the general editor, along with Thomas McGinn, of the scholarly monograph series, The Oxford Studies in Roman Society and Law. Ladies and gentlemen, it's my pleasure to cede the floor to Professor du Plessis, whose inaugural lecture takes the title, Reflections on Futures Past. Paul.
Thank you. It's always difficult to hear oneself in the third person. It's almost as if you're at your own wake or so. So, Right, let's start. Professor Hogg, colleagues and friends, when the Roman poet Virgil began to compose the Aeneid, an epic poem chronicling the adventures of Aeneas, a Trojan warrior whose distant offspring would one day establish the greatest empire of antiquity, he was, like so many of us who write for a living, confronted with the problem of the perfect first sentence. The Aeneid was designed to be no ordinary poem. It blended the genres of poetry and history, first separated by Aristotle during the 4th century BCE, into a heady mix of determinism and propaganda, as a work produced during the reign of Rome's first emperor Augustus to remind the Romans, after the collapse of their republic, of their destiny to rule the world. Virgil was well aware that a perfect first sentence would make all the difference in a work of this scope and ambition. We do not know how many bad first drafts there may have been for this sentence, but the eventual winner of arms and the man I sing, who forced by fate and haughty Juno's unrelenting hate, expelled and exiled left the Trojan shore, was as near to perfect as one could get. No surprise, therefore, that it has since become one of the most celebrated sentences in history. Such was its fame that this sentence was even echoed 6 centuries later by the Emperor Justinian in his imperial decree included at the front of the institutes, the first textbook for law students, when he wrote, "Imperial majesty should not only be decorated with arms, but also armed with laws." One should never underestimate the power and longevity of a perfect first sentence. There is, however, much more to this opening sentence than merely exquisite prose. Within these few lines, Virgil summarized the entire plot of the Aeneid, and in doing so, provided a historical narrative that would resonate for centuries, millennia even, in the collective imagination. Such is the power of history. In a nutshell, history consists of records of past events and experiences which, with the benefit of hindsight, have been judged to have some significance for the present. As the Roman jurist Javelinus reminds us in the Digest, however, all definitions are perilous. The same applies to this definition of history. Many intellectual concerns lurk behind this straightforward statement. Thus, for example, if history does not encompass the sum total of all experiences and events of the past, but only a selection, the personal persons who make the selection and the basis on which such a selection is made become relevant. Furthermore, even with the perfect vision afforded by hindsight, making value judgments such as significance and influence are by no means easy. Although matters of this kind have occupied the minds of historians at least since the time of the German philosopher Georg Hegel in the early 19th century, none of these concerns have as yet been shown to be fatal to historical inquiry. After all, historians have been practicing history quite successfully, despite these complications, since the so-called father of history, Thucydides, wrote the history of the Peloponnesian War in the 5th century BC. And so to counteract any biases that might arise in the selection of material or in their interpretation, historians have been urged to adopt 2 basic laws governing their craft. First of all, be truthful, the historian's main task, according to Cicero. And secondly, account for the past using the best possible evidence. Now, while history has been recorded ever since early man first drew a picture of an antelope on the wall of a cave as a reminder of a successful hunt, history as the object of academic study did not appear until much later. It was not until the Renaissance, circa 1300 to 1600, that the study of history as an academic discipline emerged within the context of the growth of university education. The collapse of the Byzantine Empire in 1453 and the invention of movable type printing by Johannes Gutenberg shortly before in circa 1439 had led to a marked increase in the availability of new texts from antiquity, including legal texts. This renewed interest in the past reflected a broader ideal of Renaissance scholarship, namely to appreciate and to emulate the best that the classical world of Greece and Rome had to offer. But whereas the distant past, Greece and Rome, represented something to emulate, the recent past fared less well. Renaissance historians had to find a way to distinguish their present from the recent past. This was done through the invention of history's favorite pastime, if you'll pardon that terrible pun, periodization. And since the present was infinitely better than what had come before, so scholars of the Renaissance argued, the recent past had to be portrayed in a negative light. And so, the Middle Ages, that dark and dreary period between the glory of Greece and Rome and the cultural rebirth of the Renaissance, was first identified in scholarship. As we shall presently see, periodization had one important consequence. With the identification of the Middle Ages as a period in the history of humanity, the seeds were sown for a much larger and pervasive idea of progress, to which I will return. But history as the object of study, even though it had arisen during the Renaissance, would not be recognized as an independent academic field for quite some time yet. Approaches such as social, cultural, or intellectual history simply did not yet exist. Instead, history was treated, in the words of the German scholars of the 19th century, as a Hilfswissenschaft to the two main subjects on which the late medieval university had been founded, namely law and theology. In fact, the first so-called professional academic historians, in other words, persons who studied and taught history in its own right, separate from the study of law and theology, did not appear in Europe until the 19th century. Chairs in Roman and canon law, on the other hand, were created in medieval universities, at least from the 12th century onwards. Thus, when we speak of the academic subject called legal history, that is history with a specific focus on the doctrines and architecture of one or more legal systems, this duality must be acknowledged. More importantly, the motives for and context in which many of the great works of European legal history were produced must be identified and carefully interrogated. And for those who are a bit rusty on their 19th century European history, it was the culmination of a period of nationalism that had begun in the early modern period and in which the nation-state was an important building block. It is commonly said that European legal history as an academic subject started with the publication of Friedrich Karl von Savigny's Geschichte des römischen Recht im Mittelalter, 1815 to 1831, a multi-volumed work in which the author set about exploring the rediscovery of the compilation of Roman law created by order of the Emperor Justinian and its use by the jurists of the late medieval period as a teaching tool at the great universities of northern Italy in the 12th to the 15th centuries. It is also in this work by Savigny, one of the greatest German jurists of his generation, that the roots of the idea of a jus commune, a medieval common law of Europe, based on an amalgam of Roman canon and feudal law, first appears. Another fact increasingly being stressed in modern works on the subject, by scholars such as Whitman, Le Saffert, Modir, Duve, is that the Geschichte was specifically written by Savigny in the context of his famous intellectual debate with Anton Thibaut, another celebrated German jurist, over the desirability of the codification of the private law of the German Empire, an idea which Savigny, owing to his belief that the authority of the law resided in the spirit of the people, the Volksgeist, rather than the will of the sovereign, staunchly opposed. Instead of legislation produced by the will of the sovereign, Savigny argued that the law of the unified German Empire should consist of uncodified legal doctrine developed through academic discourse, a so-called Professorenrecht, the roots of which he saw in the intellectual activities of the legal scholars of the medieval jus commune. Ultimately, Savigny's call for an uncodified German private law informed by the Volksgeist did not succeed, for various reasons, many of them connected to a large discourse about the decline of natural law. The study of Roman law in Germany, instead, came under the influence of the Pandectists, who used the rules, doctrines, and terminologies of Roman law as the DNA and the skeleton of the German Civil Code of 1900. It does not take much to appreciate that the Pandectist approach was not exactly in keeping with Savigny's original idea. It necessitated a change in orientation. In order to create a system of law in an intellectual abstract sense, any vestiges of historicism, that is an appreciation of age and context of the various legal rules comprising that system, had to be downplayed. And once this had been achieved and given the imprimatur of the sovereign through the legislative process, the development and elaboration of legal doctrine could then become a game of mental gymnastics, a professorenrecht, removed or at least at some distance from pesky real-world concerns, to paraphrase Rudolf von Jhering's savage criticism of this approach. It is also worth noting that this pandectist turn in German private law led to the identification by the first generation of comparative law scholars at the start of the 20th century of the hallmarks of a civilian system of law, namely a codified system of private law based on general reguli juris taken from Roman law and developed through professorenrecht, with comparatively little weight being given to legal development by way of case law. The events of the First and the Second World War well and truly destroyed any connection between private law and the ideal of a Volksgeist. Adolf Hitler and his National Socialist Party saw to that. Instead, German legal scholarship forged ahead with legal positivism, and from here it was but a short intellectual hop to Hans Kelsen and the pure theory of law, which incidentally also influenced the Anglo-American supporters of legal positivism, such as H.L.A. Hart. The German narrative is not unimportant for our purposes. If the history of European legal development was constructed against the backdrop of the events of the 20th century, 2 world wars in particular, it stands to reason, given the absence of objective historical truth, that contemporary concerns about matters such as the nature of law and its authority, the place of nationalism, and latterly the interplay between law and morality would have found its way into this narrative. And one does not have to look far for these elements. Without doubt, the 2 most influential academic works in the field of European legal history in the 20th century have been Paul Koschakker's Europa und das römische Recht, 1947, and Franz Viaker's Privatrechtsgeschichte der Neuzeit of 1953. Much has been written of late about the narratives produced in these 2 books. As a product of the immediate post-World War II legal landscape, they were clearly aimed at the rehabilitation of German law and the German legal family writ large in its European context, freed from the manipulation of the rule of law suffered under the Nazi regime, as so painfully visible in the works of the legal theorist Carl Schmitt. The narrative arc presented in these 2 works may be summarized as follows. The legal systems of Europe were based on Roman law contained in the compilation created by order of the Emperor Justinian in the 6th century. Through historical accident, this compilation survived the ravages of the early medieval period and was rediscovered in the late medieval period in north of Italy, where it came to be taught in conjunction with local city laws and customs, as well as the canon law of the Church, to create the first European jus commune. As nation-states emerged in the post-medieval world, and each European jurisdiction experienced a reception of Roman legal principles, to varying degrees, but none ever as comprehensively as Germany, eventually crystallizing in various municipal legal orders. These municipal laws remained uncodified until, in the wake of the French Revolution and inspired by the ideals of natural law and reason, European jurisdictions began to codify their laws. Although Koschakker's book only hinted at the circumstances of the first half of the 20th century, Viaker's was much more explicit. According to Viaker, looking back with much sadness over what had just happened, the events of 2 world wars had demonstrated that the fragmentation of the medieval jus commune had been a mistake, and that greater European legal integration was once again required. This narrative remained dominant for much of the 20th century, bolstered by various European-wide projects such as Jus Romanum Medii Ivy, in which many Dutch and Belgian scholars participated, as well as Helmut Koying's Handbuch der Quellen und Literatur der neueren europäischen Privatrechtsgeschichte, produced by the Max Planck Institute for European Legal History. These 2 projects looked behind the pandectist approach to the German Civil Code of 1900, but they were still very much of their time and treated the legal development of doctrine as their main focus as a sort of fil rouge from Justinian to the drafters of the European civil codes. But the narrative constructed in the works of Cochaker and Viaker, respectively, as has recently been pointed out by various scholars, including Chalmodier, participating in the newly published Oxford Handbook of European Legal History, had a number of implicit assumptions. First and foremost, the perspective was wholly German. Thus, they were written with the German Civil Code of 1900 as the constitutive legal moment for Europe, much like the Big Bang which created the universe as we now know it. Everything before 1900 was chaos, even if productively and intellectually interesting chaos, while everything afterwards was meticulously ordered, systematic, and in its proper place. As Randall Le Saffer put it recently, Cochaker, for example, saw a significant place for legal history in the dogmatic formation of lawyers through the study of the continuous progress of concepts, institutions, and doctrines from their origins to the present. The key phrase here being continuous progress. The second underlying assumption was that largely private law mattered. The history of other branches of legal inquiry was left to those in other disciplines, and in some cases could even be left to those outside the law school. This is, of course, not a bad thing, but its longer-term effect has been to create two separate discourses inhabited by two very different groups of scholars with very little common ground. The world of the scholar of Roman law, for example, is very different from those who study the same legal system externally. But the final and most pernicious assumption was that history had somehow ended in 1900. Everything thereafter was politics. Using that trusty tool of historical periodization, legal scholars confidently asserted that by the first part of the 20th century, Europe had progressed, notice the language, through at least 4 epochs of legal development: antiquity, the medieval rediscovery of Roman law and the jus commune, the early modern reception of Roman law and the formation of the nation-state, and finally the sunlit uplands of codification. Each one better than the one before. And since the system had now been perfected through rational reason, no further development was required or even desired. As Edward Gibbons so eloquently put it in his Decline and Fall, wise or fortunate is the prince who connects his own reputation with the honor and the interest of a perpetual order of men. It should by now be obvious that the central theme of my lecture today is the power of the historical narrative. In this era of fake news and alternative facts, history has become more important than ever before. And not just history generally, but legal history specifically. Legal history is central to the understanding of any legal system, no matter what its shape or form. For Scotland, where a codification moment did not occur as it did in Germany during the 19th century, and where the law progresses by and large through doctrinal alluvion, history is, one might argue, doubly important, as it is much more present in our everyday encounters with sources of law and other legal materials. There is, in this sense, an unbroken continuum between the past and the present. Like the Roman god Janus, Scots law has two faces, one turned to the past, the other towards the future. And yet, even though the legal history of Scotland has undergone a veritable renaissance through the works of John Cairns, Hector McQueen, David Seller, and their pupils, to name but a few, legal history as an academic subject remains precariously located in the curriculum of the average law school in Scotland in 2018. Relegated to the category of nice to have but not really central to what students need to know, it is left entirely up to the student to equip themselves with the rudiments of Scottish and European legal history through electives. Furthermore, and probably as a result, when it is mentioned, the history of the Scottish legal system is often quite poorly treated in mainstream legal textbooks used in Scottish law schools. The most widely used introductory works on the Scottish legal system, for example, with 1 or 2 notable exceptions of people in the audience tonight, create the impression that Scots law had somehow sprung from the head of Zeus fully formed. The question must be asked how we have arrived at this point. In my view, there is a connection between the current state of affairs and the narrative created by Savigny, elaborated by Cochaker and thereafter by Viaker. Not all of it, but at least some of it. Now, let me be clear on this point. The scholarship of many people in the audience tonight has shown that from the moment that the legal history of Scotland becomes settled enough to be studied, usually from the reign of David I in the 12th century, to the start of the Napoleonic Wars in Europe, Scotland maintained substantial and profound deep links with the European legal tradition. We see this in our legal literature, in the records of where the Scots studied law abroad, in Europe and elsewhere, their lecture notes that they brought back, and in their activities in the ecclesiastical and royal bureaucracies. And with the recent interest in the mixed legal system since the 1990s, many of those links have been renewed and indeed deepened, as both the institutional writers of Scots law and countless examples of case law, old and new, confirm Scottish legal history is intimately connected to the Roman legal experience of Europe. Roman law is and remains a substantial part of the common law of Scotland. My criticism, rather, is the way in which the legal history of Scotland at the end of the 19th century and post-1900 became bound up with this German narrative of European legal history created for very specific purposes in the second part of the 20th century. I will return to the Scottish position at present, but for the moment I wish to make some observations about this narrative first. The fundamental issue with the German narrative of legal history is that it propagates the notion of progress. Now, let me just be clear on this point. I make a distinction here between progress and change. Law changes, that is a fact, sometimes for mysterious reasons. But whether change and progress are the same thing, I'm not so convinced. In this sense, the European narrative has been utterly successful. The idea of progress has become a veritable cornerstone of modern legal thinking, even if we've seemingly never been as dissatisfied with our own legal system as we are at present. We see it in all around us in government directives, legislative agendas, endless and never-ending calls for law reform on this and that, and also in our general attitude towards the subject of legal history. Because progress, so the argument goes, in its most insidious form, somehow renders history unimportant and irrelevant. Or to put it more bluntly, old law bad, new law good. And it is not only the subject of legal history, but also those who practice it that come in for criticism, as Michael Lobban has dryly pointed out here in the quotation below. This is, of course, an overgeneralization of a more complicated issue, but the basic point is sound. It is not always clear to the community of scholars making up the modern law school what legal historians have to offer and why their subjects are important for the formation of the next generation of the legal profession. While most colleagues would admit that law has some element of history, legal professionals are busy people, so the argument goes, and the demands of contemporary practice often preclude leisurely armchair reflection about the history of a legal principle or doctrine, unless it is central to a client's case. The study of law, we are told, is first and foremost a Broodwissenschaft. As a historian of law, this is an interesting development, and the reasons for this attitude towards the history of our legal system deserves further scrutiny. There are, in my view, at least two reasons for this. The first reason is good old-fashioned hubris. In 2018, with the last world conflict fading from memory and the perception that things can only get better, it is easy to convince oneself that we are very different from those in the past. Or to use David Lowenthal's much-quoted phrase, the past is a foreign country. They do things differently there. Sadly, as any historian will tell you, people have felt this way in the past too, only to have their sense of the present cruelly dashed by larger unforeseen events. It is, of course, true that in many respects, people in 2018 have access to different resources, especially technology, in a way that those of earlier periods did not have. But as those who study evolutionary biology will reveal, evolution in man during recorded time has been social rather than biological. It would also be unwise to downplay the extent to which innovations such as these have impacted on our understanding of the world around us. But the basic biological processes through which we perceive reality and construct arguments have not changed at all. And although this may sound like a strange repackaging of natural law theory, this is not what I'm advocating. Recent research into the emergent field of biological legal history has shown that certain phenomena and processes, far from being abstractly legal, also have definite biological drivers. The second, more substantive reason may be described as a crisis in the belief about the function of history. Mainly that history and its function is to lead us into the future, like a proverbial Orpheus leading Eurydice from the underworld. Scholars are divided about the moment when the idea of progress first appears in the narrative of the function of history. But some, like the historian of ideas Donald Kelly, identify its emergence with the Renaissance. It is indeed true that the medieval understanding of history was very different. For one thing, the idea of progress did not exist at all. In its place was providence, the Christian belief that through a life of unremitting toil, a sinner could enter heaven not because of one's own good work, but through an act of pure divine mercy. While the idea of progress as a feature of history might have appeared first in the Renaissance, it really took hold in Enlightenment thinking, where under the influence of natural law and rationality, it reached an apex when nature, normally unchanging, was linked to Darwinian evolution theory. The belief in the rationality of law and the fact that new developments represent progress is painfully visible in the debate concerning the codification of private law in Germany in the 19th century. And from there, the notion of linear progress of history naturally found fertile grounds in the supporters of legal positivism. Furthermore, according to its supporters, the extreme rationality of this approach, separated from any moral concerns, combined with the belief in progress, enabled scholars to assert that history could be used in a manner to predict the future. 2 world wars and a few financial crashes later, and the idea that history progresses and that it does so in a linear fashion has well and truly been laid to rest. Apart from the historical events of the first part of the 20th century and the increasing vocal opponents of legal positivism, historians of the 20th century have pointed out that there are 2 insurmountable problems with the idea of the linear progress of history. The first of these cuts to the very heart of the notion of progress. As Paul W. Kahn, the legal theorist, has pointed out, a linear progress presupposes a beginning and an end to history, neither of which seem plausible or indeed provable. As I quote him here, progress is not a fact about a community's history, but a belief about the meaning of that history. A second point of critique relates to the fundamental basis of progress, namely the ability to identify past epochs and to assign judgment to them in terms of progress. So as the scholars of the Renaissance judged the Middle Ages to be more primitive and backward, those of subsequent periods had to do the same. This has unfortunately led to the terrible paradox of modernity/postmodernity. Since the linear nature of the historical process has now been thoroughly discredited, it is impossible to determine where on this supposed timeline we are at present, and whether there is in fact any sense of progress. As Bruno Latour, the sociologist, has reminded us, we cannot even be sure that the present epoch in which we find ourselves can really be called modernity. This crisis in the belief that history unfolds in a linear way linked to progress has had a substantial impact upon common perceptions of the purpose of history in a general sense and legal history in a particular sense. If history cannot predict the future, and one can no longer use it to show that we are currently in a better situation than people were before, then, so skeptics argue, the past truly is a different country, where things were done differently. Or to borrow a phrase attributed to Arnold Toynbee, but may in fact be from somebody else, the past becomes just one damn thing after another. And this is not unimportant for legal history. If we relegate Roman law to the elaboration of legal doctrine in a positivist way, and then begin to question history's ability to predict the future, we arrive at a point where, to quote Shakespeare, we are hoisted by our own petard. Nowhere is this more evident, ironically, than in the codified civilian systems of Europe. Ever since the late 1990s, the Belgian legal scholars Van Hoek and Oost have identified what they refer to as a crisis of European legal science. This crisis has developed along the following lines. First, whereas legal doctrine's main purpose is to systematize the law through a civil code, the long-term effect of codification has been to remove any further need for systematization. At the same time, as it has become clear that all further legal development cannot be dealt with through analogy or interpretations of existing provisions in a code of law, new pieces of legislation were added, thus limiting the scope of the existing general principles contained in the code. The absence of any further need for systematization, combined with an increase in the amount of specialist areas of law appearing, has left little space for doctrinal writing, thus leading to more descriptive rather than analytical works on law, as well as what they refer to as legal pointillism, an obsession with case law and its development. There is, of course, nothing wrong with a focus on case law, merely that the legal development through case law does not fit in with the original model of the civilian system identified by comparative law scholars in the early 20th century. It would, of course, be incorrect to attribute all of these elements of crisis to a single cause. As Montesquieu has so beautifully demonstrated, the idea of monocausation in history cannot be sustained. Nonetheless, it is clear that the way in which legal history, and Roman law specifically, has been treated in the codified civilian tradition has in the longer term led to a very limited role for it merely as the driving force behind positivist doctrine. In this way, as Koschaker has noted, Roman law becomes a wise old man with a beautiful white beard to whom one opens the door, invites in, listens with great respect, and then gracefully shows out of the house again. And given the battles which have raged between legal positivists and adherents of various reincarnations of the natural law theory since then about the nature of law and the sources of its authority, it comes as little surprise that legal history generally and Roman law specifically has suffered as a result. Few would deny today that many of the issues identified by Van Hoek and Oost in relation to European legal science are also visible in the Scottish legal system. Legal doctrine is on the decline, specialism is on the increase, and many scholars spend their time on the elaboration of case law rather than the identification or developing of existing regula juris on which Scots law following the civilian tradition is based. Now, some might argue that this is merely a sign of changes to the fabric of Scots law, to borrow a phrase from Neil Whitty. But in my view, there is at least some of it has been caused by the positivist treatment of Roman law. And to understand this, we must look firstly at the circumstances of the late 19th and early 20th centuries in Scotland. It is not a period of growth at all, either in terms of scholarship or in terms of legal education. In fact, the period is generally described as one of decline and stagnation. There is still much work to be done on the history of Scots law from the end of the 19th century until the advent of the idea of the mixed jurisdiction, first identified based on comparative law literature by Lord Cooper, the teacher of T.B. Smith. As recent research by John Cairns on the period has shown, however, the close links with German scholarship towards the end of the 19th century by Roman law scholars at this university, such as James Muirhead and Henry Gowdy, came to an abrupt end following the events of the First World War. But the influence of legal positivism did not end there. By this time, the Anglo-American school of legal positivism, built upon the works of Austin and Bentham, had found a new champion in H.L.A. Hart, who had in turn been influenced by Hans Kelsen. It is not my intention to catalogue all the instances of legal positivism visible in Scots law during this period. There are many. One may point to the dictum of Lord Dunedin in Sinclair versus Broome, or that of Lord President Dundas in Cantiere San Rocco, as well as discussions in the early volumes of the Stair Memorial Encyclopedia on the sources of Scots law. Suffice it to say that all these suggest a highly positivist environment in which Roman law was effectively relegated to the role of supporting legal doctrine. Even attempts by Cooper and Smith to make a case for linking the common law of Scotland more closely with the Volksgeist of the Scottish people did not succeed. My argument thus far has been that this relegation of Roman law to the underpinnings of Scottish legal doctrine is based on a 19th century paradigm invented for a codified civilian environment rather than an uncodified mixed jurisdiction. This narrative was based on the seminal moment of codification, which altered the relationship between Roman and private law in codified legal systems. But since this moment did not occur in Scotland, there was no need to adopt this approach, other than the sheer force of Anglo-American legal positivism. In fact, there is good evidence to suggest that such an approach did not reflect what the institutional writers of Scots law understood the function of Roman law to be. Although these writers held different opinions on the matter, and I've put a smattering of them on the wall here, they were united in their views that Roman law formed part of the unenacted law of Scotland and could be, in that sense, a source of and inspiration for a number of good ideas. Or to quote John Cairns again, in many instances, Roman law is actually or potentially Scots law. Even Arthur Duck, wonderfully named Arthur Duck, an English barrister, 1580 to 1648, whose magisterial book on the authority of the civil law tradition across various countries in Europe, published posthumously, in his description of Scotland, gave exactly the same opinion. Of course, one might argue that Scots law had again progressed to this point, or past this point even, but if you're going to make the argument that times change, you have to make it well. As the council found out in the unreported but yet wonderful decision of Bennett and Robertson versus Strachan and the Cooper Sheriff Court case from 2006, where they rather unwisely made an argument that times had changed and therefore old law need not be looked at. They were severely rebuked by the sheriff. It should be evident by now that I'm not in favor of restricting the use of Roman law in Scotland purely to the elaboration of legal doctrine. After all, in the Roman legal tradition, there are three things which we admire the Romans for: analysis, synthesis, and construction. And to limit it merely to legal doctrine would be to limit it to one of those three functions. Furthermore, to do so would have two negative consequences in the longer term. The first of these is to ossify Roman law, and indeed the Scottish common law. Or to phrase it differently, it would turn the study of Roman law into legal archaeology, in which we gently brush away the dust of millennia from the petrified skeleton of a usufruct, for example. This was never the intended function of Roman law in Scotland. It was never meant by the Scottish institutional writers to be ossified. It was designed to fulfill exactly the opposite function, namely as a living source of good ideas. The second negative consequence is that by trapping Roman law in the category of legal doctrine only, it becomes caught up in debates about positivism and natural law, which have raged for much of the 20th century over law's authority and normativity. There is nothing intrinsically wrong with the doctrinal approach to it, of course. One cannot, after all, study the physiology of the human body without studying its skeleton, or understand our evolution without decoding our DNA. In fact, even if it only fulfilled this role, and this is the role that it mainly fulfills in Europe at present, it would be worthy of a very prominent place in our legal curriculum. My argument throughout this lecture has been, however, that to limit the place of Roman law to this role only is not in keeping with the role historically envisaged for it by our institutional writers when they engage with Roman law. And since our institutional writers have been accorded authority by the Scottish courts since the 19th century, combined with the fact that Scots law remains an uncodified system that draws many of its principles from the Scottish common law, of which Roman law is a substantial part, there is no reason why other alternatives cannot be explored. One of the main functions of history, after all, is to show which paths were taken, which were not taken, why, and by whom. So how can this be achieved? There are a number of different options. One of the most measured proposals of late has been put forward by Max Delmar in a chapter in the newly published Oxford Handbook of Legal History. The nub of Delmar's argument is a call for a greater collaboration between legal history and jurisprudence. Although this is not an easy task, given the obvious differences between the disciplines, the problems are not insurmountable. In a nutshell, Delmar proposes that legal historians should become more aware of legal theory, and vice versa. By adding these insights to the existing investigations, both groups will be able to transcend the intractable legal positivist/natural law debates in favor of more significant issues. Delmar uses a very controversial example, what he calls normativity. This is perhaps not the best example that one could use. Authority might be better. But if we see the authority of law as a process rooted in time and space, then both legal theorists and legal historians will be in a position to make a substantial contribution to this debate. And this is not merely wishful thinking for the future. There is already very clear evidence in both disciplines that approaches of this kind can do much to further our knowledge. On the legal history side, one may mention the work of John Cairns on the culture and architecture of the legal profession during the 18th century, or John Ford's work on the use of civil law as legal authority in the 17th century. On the legal theory side, one could mention Jeremy Waldron's work on John Locke and Immanuel Kant, or Neil McCormick's work on law and language. Also, as Caroline Humphreys has pointed out, to look at the rhetoric employed in court submissions and judicial decisions, as well as the architecture of legal institutions, could be fruitful when examining their role in the administration of justice. All of this points to a more expansive role for Roman law than merely as the starting point of legal doctrine. When approached in this manner, it becomes possible to ask questions not only about legal doctrine, but also about larger matters underpinning the question of the authority of law, namely issues of culture. And here there is an interesting final twist. The founder of Sociology of Law as a discipline was in fact a professor of Roman law. Eugen Ehrlich, 1862 to 1922, a professor of Roman law in the twilight of the Austro-Hungarian Empire, is credited with being the founder of this discipline. Czernowitz, where he lived and taught, was an insignificant little city within the Duchy of Bukovina, but provided the inspiration for Ehrlich's greatest work, The Fundamental Principles of the Sociology of Law, which was squarely based on his knowledge of Roman law. Ehrlich noted that in the cultural melting pot that was the Austro-Hungarian Empire, the formal law of the empire as applied in the courts was often at variance with what he referred to as the living law, visible in groups and communities on the ground. Although Ehrlich's work has been subsumed today into broader discussions about law in society and law and society, his work continues to provide a rich vein of study, not just because it is so squarely based on Roman law, but also because of the savage review of his book by Hans Kelsen and the different perspective that this reveals on legal positivism versus natural law. And so we return to Aeneas, the Trojan warrior pictured here fleeing a burning Troy. Karl Marx, in the 18th Brumaire of Louis Bonaparte, wrote the following about history. Men make their own history, but they do not make it as they please. They do not make it under self-selecting circumstances, but under circumstances existing already, given and transmitted from the past. The tradition of all dead generations weighs like a nightmare on the brains of the living. As I hope to have demonstrated in my lecture, this is not how history works. It is also definitely not how legal history works. History does not predict the future like some sibyl from Cumae. Nothing can, not even the critical or the empirical disciplines upon which we place so much faith in the development of law these days. But the advantage of legal history is that it shows us the routes which we have taken and the routes that we have ignored before. It gives us a sense of our legal heritage and our culture. When Aeneas fled Troy, he was not alone. On his back, he carried his father, Anchises, clutching their household gods. This represents the past. And by his side was his young son Ascanius, representing the future. And so Aeneas becomes a metaphor for Scots law. We should do well to remember this duality. Thank you very much.